How long after a person dies will beneficiaries and heirs be notified? It depends in part on the estate planning that the deceased person did. If you're the beneficiary of a trust, you're supposed to be notified within 60 days of the date of death. If you're the beneficiary of a will or under intestate succession, you're supposed to be notified at least 15 days before the initial probate court hearing. If they had a trust, when will I be notified? If the decedent created a trust during their lifetime to pass their assets through upon their death, under California Probate Code sections 16061.7, the trustee is required to send a notice to all trust beneficiaries and heirs within 60 days of death. However, the timeline for notifying beneficiaries of their inheritance outside of a trust is more variable. This is because the deadlines are calculated based on when a petition for administration of the estate is filed, rather than from the date when the person passed. When will beneficiaries be notified if a petition for probate has been filed? Under California Probate Code section 8000, an interested party can file a petition for administration of the estate at any time after their death. A hearing will then be set for up to 45 days after the petition is filed, but at least 15 days before the hearing, the petitioner on that petition must provide notice to the estate's beneficiaries and heirs. The petitioner must also publish notification in a newspaper of general circulation in the city where the decedent resided at the time of their death, or where their property was located. What should a beneficiary do if they've not been notified of their inheritance? If you're an heir or a beneficiary of a person who's recently passed away and you've not yet been notified of your inheritance rights, you should consult with a probate litigation attorney. There may be actions that you can and need to take, because if you don't take them, you may lose your ability to protect your rights and get your inheritance. For instance, if an executor did not notify you about the probate hearing for a will, you may be able to file a will contest and request that the probate court revoke administration. You likewise can contest the validity of a trust in certain circumstances. A probate litigation attorney is going to be able to walk you through this and assist you in determining whether you have legal grounds to challenge a will or a trust, and to advise you as to the best next steps to protect yourself. Another possible action is to file a Probate Code section 11700 petition to determine distribution rights. As an heir beneficiary, you would have the right to file a petition to ask the court to determine who's entitled to receive distribution of the deceased person's property under the will or under California intestacy laws. With any of these issues, it's incredibly important to contact an experienced probate litigation lawyer as soon as you know that your rights have been violated. The California Probate Code is rather complicated and includes various deadlines and restrictions on when those challenges can be made. This means that not only could a delay allow others to cause irreparable damage to the estate, but if you wait, that could also act to see that you miss your opportunity to protect yourself and get your inheritance. For these reasons, it's vital to speak with a probate lawyer and determine a course of action sooner rather than later. Have questions? At RMO, we protect people like you every day. Schedule a free consultation at rmolawyers.com or give us a call, shoot us an email. Thanks for watching.